It's the state of Texas versus Raymond Peoples. You may call yourself and come forward. Yes, sir.
First time I've ever been charged with a crime was when I was 27 years old. And I electrocuted me through the shock box that they got on my leg because they don't want me to talk about the prior cases and why I'm in here and all the stuff that they've been doing to me. And there's so many powerful people in the government that hate my guts, not because of what I did to them, but because of who I am. I'm about to talk about every single factor from the day I was charged with the first illegal crime back in 2016, all the way up into this new crime that he just told me about of some feces being thrown on somebody. And everything that I'm about to mention is on record, or I have witnesses about. And I'm about to educate the jury about the law that y'all keep breaking, about the rules that y'all keep breaking, and how y'all like to keep trying to manipulate stuff to keep me in here. This is my fourth trial. My fourth trial. And the only time they was able to get a conviction was when it wasn't a jury in front of me. And that conviction came from a probation violation of a charge that they had no jurisdiction over in the first place. It was supposed to be in misdemeanor court, not felony court. During the jury selection 2 days ago, when the lady started transcribing this, she's gonna need it. And it was 30 minutes into it. I said, y'all not transcribing this? We're about to.
Hold on, sir. Sir.
What?
Sir, let's get relevant here. You were charged with the first-degree felony of aggravated assault against a public servant. This isn't the time to make a speech of your whole life. Let's stay within the relevant allegation. And don't interrupt the court. How many times have I said that? You have a fair opportunity to be heard. The court is required by law to direct the law to the people, and the jurors are instructed. We are focusing the relevant matters of the accusation in the four corners of this indictment. Let's stay within this. This isn't time for your life story. If you are found guilty, if we go to the punishment phase, there are matters you can bring up that are relevant to punishment. This is only about the allegation. Please stay within the four corners of the charge. Thank you, sir.
The jury, the day I'm talking about is the jury selection for this charge. So
stay within the four corners of the charge in this indictment. That's what's relevant. Thank you for following the rules.
That's what I'm doing. So there was no point in me objecting to what I was seeing on the jury selection paper because he wasn't.
Once again, sir, this is with the four corners of what happened on or about June 6, 2023. Let's don't talk about jury selection. That's not relevant to the facts. Stay within the facts, sir. Please go forward.
The Sixth Amendment says the accused shall enjoy a speedy public trial by an impartial jury. The word impartial means fair. In the district, whereas the crime shall have been committed, which shall have been previously ascertained by law, shall be confronted by the witnesses against him, which means the witness that's against me shall have said that I did whatever they charged me with. And yesterday, that man sat right here and said, yeah, you scratched me. That's how I got my injury. But yet I am indicted for stabbing him with ink pen. All persons born or neutralized in the United States.
Naturalized, sir.
Naturalized, thanks for correcting me. You're right. Naturalized in the United States. Ooh, you know this. And you know it.
Sir, just please move forward with what you need to say.
Born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. No state shall make or enforce any law which shall abridge the privileges and immunity of the citizens of the United States. Last I checked, I was born in the United States. Nor shall any state deprive any person of life, liberty, or property without due process. Last I checked, me talking about how unfair a jury is, I had the right to do that because my rights is being abridged. So I can tell the world and explain how my rights are being abridged during my testimony in the four corners of the indictment. Is that correct, Judge?
Sir, move forward and stay relevant to what the allegations are in the four corners. And please, for the 20th time, please don't speak over the court when I'm speaking. Sir, how many times have I said that to you? You have a fair opportunity to speak, but it's not on your terms. The law has its rulings. The rules of evidence have its rules, and you, in representing yourself, must follow them, whether you like it or not.
If what I just said was correct or not.
It wasn't relevant to whether the facts are. I give the law. You don't start quoting constitutional law. I'm going to give the law, sir. You just talk about the facts. Please move forward. These people have valuable time here. Let's stay within the rules. Give them what your version of the facts of this incident were. Please move forward. That's what we're here for.
So you above the laws of this country? I'm just asking
you. One more statement like that, and I must hold you in contempt of court. I don't want to do that. I've ordered you to follow the rules. Please follow the rules.
I see how Jesus feels.
That's your statement?
I'm testifying
to the facts of the case, sir.
So you telling me I can't be a character witness to myself?
Sir, give what you want to say to the jury of the facts within the allegations. That's what we're here for.
The jury is sanctioned by law.
I'm sorry, sir. This isn't a debate. Go into the facts of the case, please.
Okay.
I've made a ruling. Follow the ruling.
I'm being a character witness. Can I call myself as a character witness?
You don't do it that way. You can speak.
Can I talk about myself?
Yes, you
character witness.
The character as to character is not relevant at the guilt or innocence phase. It's at the punishment phase. You can talk about what the facts are and what might have been motivations. I'm helping you out on this. You might have been what motivations that you had in acting within the allegations here. I can't tell you what to say, but character evidence is something that is reserved for the punishment phase. That's the law. You should know that.
For the last 2 days, you've been destroying my character.
Well, sir, that's
I can't rebuild it.
You should have objected.
I did object. You told me that didn't make it. I did.
Okay, move forward. Move forward, sir.
I would like to object to the jury selection.
Overruled. Go to the facts of the case, sir.
But I need to.
Sir, it's overruled.
Before you.
Sir, it's overruled. Okay. You move forward and we'll take. I'm sorry, sir. We'll take that up outside the presence of the jury and you'll have a fair opportunity to make your statement and put the rule on, but not in front of the jury. That's not what's relevant for them. They need to know what the facts are, not what your personal feelings are about this court. Move forward.
That's not the way.
Move forward, sir.
I have to tell you what my objection is before.
No, I will do it outside the jury. We'll do it outside the presence of the jury. That's not relevant. Go.
They can do it at the jury selection.
No, sir. No, sir. That's not the appropriate way to do it. We're going to follow. I've made my ruling.
All my family that is watching this right now, this is what integrity is. This is what dignity is. This is what perseverance is. You understand me? Every juror in here is related to an officer in this county. The fact that I have a lawsuit pending against this judge right now and the federal district judge, and they still forcing me to sit in front of a jury that's not my peers, it's completely illegal. It's completely overstepping the Constitution. 3 of the jurors had close relations to Mike Laird by their own admission. One of the jurors was related to the guy that arrested me, to the officer that arrested me and broke my phone and destroyed my evidence. That I had the same officer that I had to prove set me up and framed me at the last trial of a jury that voted in my favor 11-1. Nobody in this country would have voted in my favor. That juror that voted against me was planned, was tampered with. I'm still in prison for pointing a gun at somebody. Pointing a gun, which is a misdemeanor. I didn't shoot the gun. I just pointed. By law, that is a misdemeanor. They charged me with aggravated assault. I was the sole provider in my household, and we was eating good. You understand me? My probation officer, the detective went to talk to my probation officer, trying to see what he can figure out how to violate my probation. You know what my probation officer told him on the paperwork? He's been in compliance for the past 3 years. But they hate me so much. The last 3 trials, this man had a white prosecutor. DA Michael Laird, his prosecutors was white. Miss Angela Mann, been his prosecutor. Angela Mann Neely, been his prosecutor for a while now. I've never seen nobody else working with him except Angela Mann and Waylon G. Thompson, both of which are white. But here he is on this trial. He got a black woman working with him to try to defeat the appearance of racism. Like I'm not going to acknowledge that. And then it was somebody in the jury box that was related to her. She probably don't even want to be here. Y'all probably gave her some ridiculous offer. 3 years ago, I filed a subpoena, and y'all clerks were telling me on this case, filed a subpoena on this case. And y'all clerks sitting up here telling me that I can't file a subpoena, that they can't subpoena nobody for me because they can't do it for me.
That's not an accurate statement.
That is it's on
I'm sorry.
I can tell you what day it was.
Sorry, sir.
I can tell you what day it was.
Once again, I'm going to tell you when I speak, you must stop, please. That's the rule of law. I know you don't like to follow these things, but that's the rule of law. Subpoenas, if you send subpoenas, first of all, I urge you, have an attorney to help you.
I don't need
you. I know.
I'm a jurist. I'm an expert.
The subpoenas you've submitted are inaccurate, incorrect, and weren't properly filed. That is why they were not submitted. And I urge you, get some help so you can do it properly. That's why, sir. And not everybody can. That's why people go to law school and become.
The defendant should have compulsory process and obtaining witness.
As long as it's done correctly.
I don't need a paper motion if I ask you on record in the court to do so.
All right. Go to what is relevant. That's enough on that. Go to what's relevant of the allegation of the first-degree felony of aggravated assault.
Y'all only did.
Is there anything else you want to add?
Y'all would have never charged me with this.
Is there anything else you want to add?
If I never filed the habeas corpus, I filed the habeas corpus accusing Joshua Hall, Detective Duchamp, who else? Detective Duchamp, Joshua Hall, Mike Laird, my attorney, of conspiring against me, right? I accused them in a habeas corpus back in 2022, March 9th. Ever since then, I ain't been getting no sleep because y'all want to keep sending people after me in the jailhouse to harass me. And you keep talking about they keeping me in isolation because of my behavior. I was in TDC. I had a job in TDC doing good. But as soon as I filed a lawsuit, y'all transfer me back down here, throw me directly in isolation. And you trying to talk about my behavior. No, y'all don't have me in isolation because of my behavior. You have me in isolation because of these lawsuits. Matter of fact, I'm about to show the world. You want me to stop? You don't want me to show the world? Hit that button and electrocute me right now.
Sir.
Hit that button and electrocute me right now because the world.
Sir, why don't you act properly, sir?
Oh, I'm acting very properly.
I don't believe anyone in this room thinks that, sir.
I'm pretty sure they don't because they were all handpicked.
No, sir. We're talking about common decency now, sir. The law allows you to speak, but be
Wasted
decent.
Peoples versus
Please.
Greg Addict. Now let me show y'all who name is on the front for it. Whenever you sue a judge or the DA or prosecutor, anytime you sue a government.
Sir, once again, you're charged with aggravated assault. Stay within the bounds. It is not relevant.
Depending on this too, in the federal court
This-
right now,
sir.
that y'all real messed up about.
Sir, this is an allegation
Right?
of striking somebody about the head and body. Stay within that allegation.
I'm supposed to be sitting in this court. I'm supposed to be dealing with this in the Supreme Court because my habeas corpus is pending in the Supreme Court right now.
Anything else?
Because of
Anything?
this charge.
Is there anything else you want to add?
Retaliation through conspiracy, right?
Is there anything else you want to add?
I'm going to continue.
How long do you expect for this to go on?
It's interrupting me. It's going to take all day.
No, it won't, sir. If it's not going to be relevant to the facts, I will stop this now.
Well, go
To
ahead.
the facts of the charging instrument, sir.
Do your thing.
Then it ends now. That is enough. It is not relevant anymore.
Retaliation.
That
through
is the
conspiracy.
end.
So everything I'm talking
Is there
about
anything else you want to add about the allegation?
habeas corpus in the Supreme Court. Now, I sent an emergency motion, letting them know what y'all keep doing to me, how y'all keep harassing me. That Lieutenant Tinker body cam played yesterday. He admitted that he refused to feed me, and he thought that was okay. I wasn't aware of it. So, Federal Statute 18 USC ever causes or induce any person to withhold testimony or other object from an official proceeding shall not be imprisoned more than 20 years.
All right, hold on. Again, that is not relevant to this case at all. This is a state jurisdiction case, not a United States jurisdiction. There's the federal government. It has its own sets of rules, ladies and gentlemen. I was a United States attorney for 20 years.
What about
And this is state law that we're dealing with here. Distinct laws. Distinct law.
focus on?
Sir, let me complete the instruction of law to the jury. Please, once again, for the 100th time, don't interrupt when the court's given the law. Thank you. That is not relevant to what the charge is in this case. This is a state jurisdiction case with its own elements. We're not trying a federal crime right here in this court.
If two or more conspire to injure, oppress, or intimidate any person in any state on account of any right or for exercising the same, shall not be imprisoned.
What are you reading from, sir?
This is federal statute.
That is, once again, its own set of rules. This is not what we're not a federal
18
court.
USC.
I know. 20 years I dealt with that.
Why do y'all hate me so much?
Anything else you want to add, sir?
5 months after I filed a lawsuit on a judge for refusing to issue the writ of my habeas corpus, after my attorney admitted to refusing to give me the search warrants, why is Lieutenant Ford all of a sudden coming harassing me like I did something to him? Why? I hated that man because he kept on squirting waste in my tail because I wouldn't sell him a pack of cookies. Levine won't clean out my cell, man. Can you please make Levine clean out my cell and let me go in and take a shower? Or look, matter of fact, just give me some of that bleach and give me a towel and I'll clean out myself. Man, I ain't trying to die, man. This corona was serious. It was 2022. Corona was serious, still serious. You know what he did? You need to stop arguing with people. You need to stop arguing with people, grievous, man. Wave his hand. Walk off. My heart must have dropped. So you gonna leave me in this? You gonna leave me sitting in another man's waist? Explain to me when I take you to your isolation tip. What? You gonna put me in isolation for dashing an inmate? You ain't trying to do no talking, cup up, or I'm coming there and get you. What? Really? You ain't gonna clean up this waste, but you gonna come in here? Or you gonna come in here to hurt me, but you ain't gonna clean up? All right. Come on, let's fight me. Because I'm not cupping up. Now, I'm not about to cup up for you to hurt. Now, I cup up for you to clean this clean his white cell out, and then you can write me up if you want me to, and block my privileges. But you're not about to come in here and put me in an isolation cell after refusing to clean out this net. Run down on me after I get done dashing him with the water, not waste. Being in another man's waste, I was throwing up. So I can't touch my own. Listen, this day I didn't swing at nobody. I didn't threaten to stab nobody. You know what I'm saying? You give me to the isolation cell. I had all my paperwork, all my legal work.
The proceeding in the state of Texas versus Raymond Peoples began with the defendant coming forward and immediately explaining that he wanted to discuss his entire history, his prior criminal cases, and what he believed had been done to him by government officials. He stated that the first time he had ever been charged with a crime was when he was 27 years old. He then alleged that a shock device attached to his leg had been used to electrocute him because authorities did not want him to discuss his earlier cases or explain why he was incarcerated. He claimed that powerful people in the government hated him because of who he was rather than because of what he had done. He said he intended to discuss everything from the time he was first charged in 2016 to the current case, and maintained that everything he was about to mention was either on the record or supported by witnesses. He also said he intended to educate the jury about laws and rules that he believed the court was repeatedly violating. He described the proceeding as his fourth trial and claimed that the government had only obtained a conviction against him when there was no jury in front of him. He argued that an earlier conviction had resulted from probation violation involving a charge over which he believed the court lacked jurisdiction because he believed it belonged in misdemeanor court rather than felony court. The judge immediately interrupted and told the defendant to focus on the actual allegation before the court. The judge explained that Peoples was charged with a first-degree felony of aggravated assault against a public servant and that the current testimony was not an opportunity to make a speech about his entire life. The judge repeatedly instructed him to remain within the facts contained in the indictment and warned him not to interrupt the court. The judge emphasized that Peoples had a fair opportunity to be heard, but that the rules of the courtroom still applied. The judge explained that the jury had to focus on the relevant matters within the four corners of the indictment. If the case reached the punishment phase after a guilty verdict, the defendant would have an opportunity to discuss matters relevant to punishment. But during the guilt or innocence stage, he needed to address the allegations themselves. Peoples continued to discuss jury selection and claimed that problems had occurred during the selection process. The judge told him several times that jury selection complaints were not relevant to the facts of the June 6, 2023 incident being tried. Peoples then invoked the Sixth Amendment and discussed his right to a speedy and public trial by an impartial jury. He explained his understanding of the word impartial and referred to the right to confront witnesses. He argued that a witness against him should have testified that he committed the act for which he was charged. He then described testimony from a previous day, saying that a man had admitted Peoples scratched him and that this caused a man's injury, while Peoples was nevertheless accused of stabbing him with ink. Peoples then moved into constitutional arguments about citizenship and due process. He referred to constitutional language concerning people born or naturalized in the United States and the protection of citizens' privileges and immunities. He argued that because he was born in the United States, the state could not deprive him of life, liberty, or property without due process. He believed that discussing the alleged unfairness of the jury was part of his constitutional right to explain to the world how his rights were being violated. The judge rejected that approach and again told him to provide his version of the facts of the incident. The judge explained that Peoples was representing himself and therefore had to follow the rules of evidence and courtroom procedure even if he disagreed with them. The judge also told him that constitutional law would be explained by the court and that the defendant should concentrate on the facts. Peoples then asked whether he could act as a character witness for himself. The judge explained that character evidence was generally relevant to the punishment phase and that, during the guilt or innocence phase, the defendant needed to testify about facts and possible motivations connected to the charged conduct. Peoples complained that the court had spent the previous 2 days destroying his character. The judge told him that he could have objected at the proper time and again directed him to move forward. When Peoples attempted to object to the jury selection in front of the jury, the judge overruled the objection and explained that such matters could be addressed outside the presence of the jury. The judge repeatedly emphasized that the jurors needed to hear the fact of the case rather than the defendant's personal feelings about the court. Instead, Peoples began attacking the jury and making accusations about possible relationships between jurors, officers, prosecutors, and other people connected with the case. He claimed that every juror was related to an officer in the county, and that he had a lawsuit pending against a judge and a federal district judge. He argued that he was being forced to sit before a jury that was not composed of his peers, and declared the situation unconstitutional and illegal. He claimed that several jurors had close relationships with people involved in the case, and that one juror was related to the officer who arrested him, broke his phone, and destroyed evidence that Peoples believed would prove he had been framed. He referred to an earlier trial in which he claimed the jury had voted in his favor. Peoples also discussed a prior conviction involving pointing a gun at someone. He argued that he had never fired a gun and had only pointed it, questioning why the conduct resulted in an aggravated assault charge. He said he had been the sole provider for his household and claimed that his probation officer had confirmed that he had been compliant for several years. He then turned his attention to the prosecution, discussing the race of prosecutors who had handled his previous cases and alleging that the current prosecution was using a black female prosecutor to avoid the appearance of racism. He also claimed that someone in the jury box was related to the prosecutor and suggested that the jury had been improperly influenced. The defendant next complained about subpoenas. He said court clerks had told him that they could not subpoena witnesses for him and insisted that this was inaccurate. The judge explained that a defendant does have compulsory process rights, but that subpoenas must be prepared and filed correctly. The judge said some of Peoples' submissions appeared to be inaccurate, incorrect, or improperly filed, and advised him to obtain legal assistance so that the process could be handled properly. The judge again directed him back to the aggravated assault allegation. Peoples then claimed that he had filed a habeas corpus action accusing several people, including officers, the prosecutor, and his attorney, of conspiring against him. He said he had filed that action in March 2022 and had suffered harassment and sleep problems ever since. Peoples argued that his placement in isolation was retaliation for filing lawsuits rather than punishment for his behavior. He said he had previously worked while incarcerated at another Texas Department of Criminal Justice facility and had been doing well there. But after filing a lawsuit, he was transferred and placed directly into isolation. He claimed officials periodically cut off his water and said he had to argue repeatedly to have it restored. At one point, he challenged the court to activate the alleged shock device and electrocute him immediately so that the world could see what was happening. The judge told him to act properly and explained that although the law allowed him to speak, basic courtroom decency was still required. Peoples continued to discuss federal litigation, alleged retaliation, and jail treatment instead of the assault charge. He described an incident involving a lieutenant and complained about being refused food, cleaning supplies, a shower, and other basic requests. He described waste in his cell and said he asked for bleach and a towel so he could clean the cell himself. He said officers threatened to place him in isolation and claimed he would not submit to handcuffing because he believed they intended to hurt him. He also alleged that when he was placed in isolation, his legal papers, legal books, and photographs of his children were thrown away. He described what he believed was an improper strip search and claimed officers made him remove his clothes, squat, and cough while cameras recorded him. He suggested that the recording was being done for improper reasons. Peoples again invoked habeas corpus and argued that it protected his right to have his claims heard. The judge stopped him and explained that those matters were not relevant to the current trial because Peoples continued interrupting. The judge warned that he could be removed from the courtroom and that the trial could continue while he listened from a holding area. The jury was eventually excused so the court could address the defendant's conduct outside the jury's presence. The judge said that Peoples had repeatedly discussed matters unrelated to the trial and warned that another interruption could result in him being placed in a holding cell. The prosecution's closing argument focused on the actual conduct that formed the basis of the aggravated assault charge. The prosecutor argued that the defendant's constant claims about lawsuits, retaliation, and other proceedings were distractions from the evidence. The prosecutor said Peoples had already raised many of these complaints in appellate courts and other proceedings, where they had been denied, yet he continued repeating them whenever he did not receive the result he wanted. The prosecutor argued that the incident on June 6, 2023 was a violent act and that the physical evidence and testimony demonstrated what happened. The The prosecutor focused particularly on evidence that Peoples had wrapped his hands in cloth and placed pins in them before coming out of the cell with a mattress positioned in front of him. The state argued that these actions showed preparation for a confrontation and an intention to cause harm. The prosecutor referred to Lieutenant Ford's testimony that Peoples lunged toward his face while still holding the pins, for experienced pain and sustained scratches. The prosecutor argued that the sharp object was important because the evidence suggested that Peoples was attempting to strike the officer in the eye and missed, causing injuries elsewhere. The prosecutor also discussed the testimony of other witnesses concerning the condition of the cell. One witness, Mr. Darby, reportedly walked to the cell, looked inside for roughly 30 or 40 seconds, and did not confirm conditions Peoples had described. Other officers also examined the cell and said it was fine. The prosecutor characterized Peoples' complaints about the cell as a smoke screen designed to distract the jury from the assault itself. The prosecutor argued that Peoples repeatedly created distractions whenever he did not get what he wanted. The prosecution also emphasized the defendant's behavior toward jail personnel. The prosecutor described incidents in which Peoples argued, grabbed the cell door, refused instructions, and yelled threats. The prosecutor referred to threats from inside the cell, including a threat to kill and the use of a racial slur that the prosecutor chose not to repeat. The prosecutor argued that the defendant's behavior had escalated over something as minor as a food tray. According to the state, an officer eventually gave Peoples a requested tray, which the prosecutor believed rewarded the disruptive behavior. The prosecutor urged the jury to examine Lieutenant Ford's injuries and argued that the sharp objects had been directed toward the officer rather than being used merely to scratch him. The state told the jury that it should not focus on sympathy for Peoples and instead should consider the officer who had to deal with the defendant's behavior. The prosecutor framed the choice as whether the jury would allow Peoples to continue acting as though he controlled the jail and courtroom or would hold him responsible for his actions. The state asked the jury to find him guilty and move to the punishment phase. The jury returned a guilty verdict in cause number 23, CR 727, finding Raymond Peoples guilty of aggravated assault against a public servant as charged in the indictment. Even after the verdict, Peoples continued speaking and interrupting. The court reminded him that he had voluntarily chosen when to speak and that he had to follow the same courtroom rules as everyone else. The prosecutor then presented the punishment argument. The prosecutor explained that Peoples had previously been placed on probation and had been given an opportunity to avoid a conviction if he accepted responsibility and behaved himself. He had been given 10 years of probation and could potentially have completed it without a conviction. But the prosecutor argued that his inability to follow rules was a recurring pattern. The prosecutor said that Peoples' behavior might appear almost humorous during a courtroom proceeding because of his repeated outbursts, but it was not humorous in a jail environment where dangerous objects were available. The state referred to allegations that he had thrown feces at people, attempted to escape, and engaged in other behavior that made life difficult for officers and other inmates. The prosecutor emphasized that Peoples was facing a punishment range of 15 years to life and still treated the proceedings as though they were a game. The state also pointed out that Peoples had already been serving a 20-year sentence when the conduct occurred, meaning the existing sentence had not deterred him. During the punishment argument, Peoples repeatedly interrupted the prosecutor. The judge warned him that the prosecutor had a legal right to make the final argument without interruption, and that Peoples had given up his own opportunity for a final argument by failing to follow the rules. The judge counted multiple instances in which the defendant defied the court's orders and interrupted the prosecution. The defendant attempted to characterize one interruption as an objection, but the judge determined that it was not a proper legal objection and instructed the prosecutor to continue. The jury was then sent to deliberate on punishment. The court warned Peoples not to speak to the jurors as they left because doing so would be improper. After deliberation, the defendant was ordered to rise for the punishment proceeding, but he refused. The jury assessed punishment at 40 years in the institutional division of the Texas Department of Criminal Justice. The state explained that Peoples was already serving a 20-year sentence and remained under the custody of the Texas Department of Criminal Justice. So the prosecution requested that the new 40-year sentence be stacked on top of the existing sentence. The judge formally sentenced Peoples to 40 years in the institutional division of the Texas Department of Criminal Justice and ordered that the new sentence would begin after completion of the prior sentence, making the terms consecutive. The court then remanded him to the custody of the sheriff of Jefferson County, Texas. Even during the formal sentencing, Peoples continued shouting and speaking over the court. The judge noted that the defendant had been given more leeway than many other defendants during the judge's history of 616 jury trials in that courtroom. But the defendant had remained defiant and repeatedly refused to follow the court's instructions. As he was led away, he continued shouting while the judge attempted to complete the formal judgment and sentencing. The hearing ended with the 40-year consecutive sentence imposed after the jury found him guilty of aggravated assault against a public servant,